release you on bail, then it is your bounden duty to be at the court. I can understand if you fall sick, then get a medical. That is requirement because if
So,
you're
so,
working,
so, okay, I understand this, and I'm not,
right?
but give, let's say, time in now. Some people complain that they're told that they have to be at court for 9 hours. But in many instances, the cases don't call sometimes until just before lunch, or one person would have messaged to say, well, they were at the court, they left after not hearing their name, across the road to get something to eat because they traveled from some distance. By the time they got up there, apparently their name was called, and the magistrate dispensed of that because it was called 3 times, but they were out just out on the road at that time.
I don't want to interrupt you, but let me get that clear. In the hub court, you would find most of the courts start at 9 o'clock. That is the standard time. It might start a little bit of other engagement. Court would start roughly quarter to 9, the earliest. But once the matters are called and the person goes to the prosecutor or the orderly and mention, listen, I was there, I just went to the washroom, the matter is recalled. That is happening at the hub. It was happening in my time and so on. Even if an arrest warrant is issued while the person was away, the magistrate recalls that warrant, give the person their date. But
Or
in
at least, or would you say quickly, what if it is that they will have to excuse themselves from the court?
they should
They should
notify
notify.
exactly.
Okay, all right.
Courtesy would entails that. So you notify the prosecutor or the orderly, which is the person that is responsible for calling your name, that you're just going to the washroom or what have you. And I would take that as before, but now they're what we call sound systems outside. So you can't see and hear your name stand. Not now.
Well, I know I don't go to court.
So I'm just
I
I'm
know, I know, I know. I'm just playing with you
for
with that
instance,
one.
say I have another instance where warrants can be issued, and this, even though this is not the in the police matters, these are in child support matters, where persons may apply for maintenance, either under the Domestic Violence Act or strictly under the maintenance ordinance. And when the person, let me say, the parent fails to honor those orders, after 6 weeks, the person who take them to court for the maintenance can apply for a warrant. So what they issue first now is a distress warrant that is executed on the person if he or she, and I'm using he or she because if children and the woman is living scotch free, he can apply for child support now. So it's no longer just one side, but the men, I'm not sure why they're not utilizing the services. Maybe they're shame, but
Or
I've
they're
come
not
across
aware.
them. Well, I'm making them aware now. So if they're in possession of the children, they can apply for services because of recent a woman would have been committed for 10 days because she would have failed to pay the $240,000 child support. So the thing of it is that a warrant was issued for her, the distress warrant. She hadn't the money, so the warrant was backed by the station sergeant, and an application was made for an arrest warrant. And the arrest warrant was issued. She was picked up. She hadn't the money, and she was a guest of the state for 10 days. So that is where an affiliation warrant is issued, right? And then you have the commitment warrant. Either you're present there in court, the magistrate issued the commitment warrant after you're found guilty, you goes to prison. Or even in absentia, the arrest warrant, the commitment warrant will be issued. The orderly uplift, signs uplift it. It passes through the court superintendent office warrant section, and then we dispose it to wherever. But of recent, I have not been sending out sentence warrant because most arise in the Georgetown area. So as soon as they picks up the person, they come to the office, they uplift the warrant, and they're conveyed to either Louisiana or wherever. And you're a guest of the state.
You're a guest of the state.
Yes, I'd advise that once you're charged, you stand a better opportunity to go and defend your case, as opposed to when you run, you make the work easier on the prosecutor. You have nobody to contest against. You just present all that you have to present.
All
Right.
right. At 21 hours 40, I want to invite you to put on a headphone because I'm going to open the phone lines now and see if I could take a couple of calls with some
Maybe it's Sunday
questions.
or something.
Uh, don't worry. Put it on. It's going to work. It's going to work. Get it there. Once you get it around your ears, you got it there, right?
Yes.
So you're hearing me. All right. So I think we've got a caller online. I'd like to say, caller, good evening to you. Welcome to Police and You.
Hi, good evening, Stan. Good evening to your guest here, ASP Daniels.
Good evening, sir.
What I'm trying to clarify is I'm a little boy here in the issue of people wasting the court's time. No, the court's supposed to be. I want to know the court do voluntary work or charity. I don't know which word to use. I I try to understand how come can people be wasting the court time. Now let me spell to you an example. I was called as a witness at one time, and I spent a whole day in court just a year. The matter has been adjourned. I'm at a loss, or I'm pausing to find out how you wasting the court's time. These judge and magistrate don't be paid for the service they're offering. How come can you be wasting the court time? I don't know. I'm glad if any legal mind can really clarify that.
When you
I
say,
cannot hear in that.
yeah, but when you say wasting the court's time, who wasting the court's time? A person who goes to give evidence, or they have a case before the court, or the
No,
prosecutor.
no. Too often you hear the judge and magistrate. I work in the legal fraternity for a short time, but for over a period of time, you hear the judge or the magistrate is saying that, you know what, people are wasting the court's time. I can understand that. I wish if any legal-minded person could probably call in and clarify what they mean by that.
All right, but let me see if the court soup is going to be able to attempt to answer that too. But thanks for coming through.
I'm trying myself to find out when he's saying that wasting the court time what he meant. Because if you're looking at it, that you shows up for court, the magistrate don't have one matter that he or she's dealing with. We have Monday, Wednesdays, and Fridays is deemed are deemed bail court days. We have 60 matters being filed. Let me say sometimes you have 17 new matters, which are hybrid matters breaking into robbery and arms and these matters. The magistrate court start at 9 o'clock. Yes, the magistrates are there. These are fresh matters coming, reaching the magistrate bundles and the prosecutor's bundles, where they might have 40 matters already set, so they have another 30 matters. It's not that I'm trying to defend, but when you look at it, the magistrates are still writing notes, and we're still doing things, even though they're trying now to create some system whereby you could have recordings and these things done. But when you look at it, for example, you might have one person coming before the court with 15 different charges. There are hybrid matters. The information is sworn to. The magistrate now have to read all 15 those charges, then ask the prosecutor, how are you going to proceed with these matters? The prosecutor decides the mode of trial. The prosecutor then said, Madam, look, application for the AJ slash this summary disposal. The magistrate now have to sit there, read all 15 of those charges back to that accused or defendant as they finish entering the plea. Bear in mind that every time the magistrate read a charge, they have to record a not guilty plea until they reach the 15th charge. And I'm just giving an average. Sometimes they have 30, sometimes they have 50, sometimes they have, especially with these frauds, right? So the thing of it, to say that the court or somebody is wasting somebody's time, unless you sit in the position of a magistrate or a prosecutor, because sometimes it is be drained, right? Because when you look at it, the magistrate might you might send for 5 witnesses. They have to write some lengthy witnesses, for example, narcotics, firearm witnesses, expert witnesses. These are lengthy witnesses. So sometimes when I was in the court, I would guide my magistrate. I said, Madam, look, we put 2 PIs today. So we work one morning, we work one afternoon. And you're surprised. Sometimes you won't even get through with 10 witnesses. So I think it is unfair to either bash the prosecutors as well as the magistrates, because it it is not easy sitting there and now with a mask over your face reading 30 charges. It's like reading 60 charges. And you still have to get to the 40 that you would have already have on your docket by the end of the day, because of COVID, the matters are now 1 hour away. The court time is now cut to 3 o'clock. So the court will have to close off within 2:30. So I understand the constraint that witnesses goes through. That is why now that I said earlier, I would have indicated that COVID came, yes, COVID came with its negative, but there is also a positive because witnesses can join in from wherever they are and give their evidence from home, provided they are in possession statements and the prosecutor lays on with them. That is some of the mechanism that I would have implemented since joining the court office. Right, and recently we had our ex Minister Roy. I would have liaisoned with the prosecutor and I encouraged her. He was, a little the uncertainty of giving it, but he gave the evidence and he gave perfect evidence. He was properly briefed by the prosecutor and he gave his evidence by his own. The person now is a guest of the state. Right? So I would not consider it, and those are some of the times. Sometimes you may be asked to return to the court. Yes, in all fairness, sometimes I, I as a prosecutor, used to feel a way when you send for witnesses. I would ask the court, please note, madam, or please note, sir, because I would have worked with multiple magistrates. Some of them are judges now, right? Some, and I would ask them, please note the presence of the witnesses. And then I would ask the court, to apologize. And most magistrates to the witnesses because of the workload, they could not have gotten to it. Even though you try to cut down, you still have to. And then when you look at it, the court again mentioned but wasting time. We're talking about a deposition in a murder PI. Murder PI is where the witness goes into the box and he or she let me talk, 20 pages of evidence that magistrate sits there and writes. When the magistrate is through, the magistrate, before moving to another witness, the magistrate have to read over all 25 pages. God, that is a deposition. It must be taken down by the magistrate in the presence of the accused and read over to the witness and signed by the witness. So the magistrate have to give the instruction to the clerk to ensure that that witness initial where a little error is and signs. So sometimes it is be hard when the witness is asked to come back, but I I think the justice system is working and we're getting there.
And I think, if I may, from a layman's point of view, add to what you're saying in terms of, uh, I know you call it, say, have maybe some lawyer expert person calling in this, but I think one of the things I've seen where that term wasting court's time has been used has been in cases, particularly where there is video evidence of someone committing a
Yes.
crime. They stand in the court and they claim to be not guilty. And then eventually, after a lengthy trial, they're found guilty. And you might have heard some magistrates instituting an additional sentence, or saying, well, for wasting the court's time. Or you might have heard the term used then. Or you might have heard, for example, the reverse, where a person might have said, well, I don't want to waste the court's time. I think we had a matter today, only today, that was dispensed,
Yes.
where an individual stood up and right away said guilty. And so the layman on the street is saying, well, he ain't playing, he ain't waste the court time. Could it be a situation like that that people are referring to?
Yes, for example, a person's found, well, you got it right. You're entitled to, even if you're found with the gun or the drugs in your crotch, you go to the court, you're fully aware that it was found there, it is strapped to your body, and you still go to the court and you plead not guilty. The photographs are there, and the court is embarked on the trial when the court could have been dealing with somebody who's incarcerated. That is categorically wasting the court's time. So if at the end of the trial you expect the magistrate to be lenient with you, the law gave the magistrate a mandate between 1 year to 5 years. So the magistrate could give you 18 months. And I enjoy when the magistrates give them months because it's calendar months. Because when you give them years, they're back out on the road to the same old story. So the thing of it is that there's nothing like additional sentence. The magistrates are creatures of statute. They're bound
So
by
they
the
work
law.
within as you
They
said, the
work
1 to 5.
exactly, right? So some magistrates give it 56 months, 60 months, same 5 years. Whereas if you're given 5 years, you go to the prison, you might spend 45 months, but within the 60 months, which is the same 5 years, you are asked to spend the calendar months, right? So the thing of it is that defendants do benefit from not wasting the court's time because, for example, if you know you commit an offense, it goes before the court, and at the first option, you throw yourself to the mercy of the court, then the court tends within a ratio of 1 to 5 year, you might get a 2 year or 18 months, and that would have seen as a completed case, as opposed to have it lying there, and at the end of the day, you take the court right to the trial, and at the final moment, then you change your plea, which is still your right, and it's your entitlement. Nobody should force you or tell you how to plea. It is your choice. So when the penalty is imposed, it is also your choice.
21 hours 51. We've got another caller online. Caller, very good evening to you. Welcome to the police and you.
Good evening, Stan, to you and your panel. Good evening, ASP.
Very good evening to you, sir.
I'm kind of interested, how does a magistrate or a judge determine whether a person would have given a statement free and voluntary? My reason is, I'm an elder person, almost a pensioner. And in 1983, the 13th of May, I was sentenced to 6 months for robbery with violence, which I did not commit. But the magistrate said, okay, yes, you would have given a statement, and this statement is what you would have given. I did not. So I would like to understand the term. How does they determine whether or not a statement is free and voluntary? Thank you, ASP, and I would like to have a tangible answer. Thank you.
I will give you a tangible answer. Early in the program, I would have indicated to you, after Mrs. Gouveia would have posed a question about the allegations. Now, once there is an issue surrounding a caution statement or any oral statement, a matter of fact, attributed towards a defendant or an accused person, once there is an allegation or some submission, if the person submissions, if the person is legally represented, or even if the person is representing him or herself, the magistrate immediately embarks on a voir dire to determine the voluntariness as it relates to giving a statement. And the prosecutor starts with conducting, sir, that voir dire, whereby you start with leading evidence from the time of the arrest to where you were held. That is bringing the station sergeant, bringing the meals book, and everything. Then we goes to the lockups if possible. And if you claim that the police would have been beating you, somebody would have here. You would have exhibited marks of violence. You would have gone to the court, and at the very first opportunity, you would have laid over that to the magistrate. So I would have been privileged to sit in multiples of what you call voir dires, right? And the magistrate don't play or take no statement just on a word of mouth. None. They conduct in-depth voir dires. And at the end of the day, if the magistrate is satisfied that the statement was not freely given, then out goes the case. And that is happening even in the High Court, because I would follow matters from time to time of interest. Right? All courts I contact safely and indicate to you in the magistrate court once an issue is raised as it relates to the circumstances surrounding the taking of a caution statement, or even an oral statement attributed to an accused person or a defendant, which is in the hybrid matters and summary matters. The magistrate make a note of it, ask the prosecutor to embark on a voir dire, and that is it. And the magistrate ruling is what the court has to be bounded by. Likewise in the High Court.
All right.
I hope that may have assisted you and clarify what would have been bugging you from 1983 to now, sir.
Awesome. And I think also because of the fact that we've got more advanced technology now to determine the situation too. 21 hours 55. Court Superintendent, can you tell us, can an accused request a change of court for a trial? And if so, what is the procedure? You know, I've heard some people say, not me, I ain't want to go in front of the magistrate. She's brick, or he is this, or what's not. Can they request simply because they don't like, or if so, what is the procedure?
Well, I know many accused used to say, I want to go before the charge red lady. That's just a side. But I don't know the problem, but the thing of it is that, yes, there's your right. You can request. But the thing of it is that you have to have legitimate legal grounds. And the magistrate, you pose the application to the magistrate, and the magistrate will determine whether it warrants a removal or not. If the magistrate does not grant you that, then you're not shut out. You can seek, if you can afford an attorney, you solicit one, or you seek the legal aid clinic in having one and file redress in the High Court, and the court will decide whether the magistrate should hear the matters or not.
Let's take another call before I go on. Caller, good evening to you. Welcome to Police and You.
Good evening, and thank you again, Mr. Stan. I did not, wasn't beaten, sorry. They asked me to sign because I was being placed in the lockup. I gave no statement, but a statement was presented before Miss Chinta. And she said that I gave a free and voluntary statement, which I did not. And ASP, your answer wasn't tangible. I didn't understand. I could have barely understood what you have said, because it was contrary to everything that I have said and what had happened to me in that few years ago.
Yes,
Thank
sir.
you.
I'm going to stand my ground on my answer. Same thing goes. Recently, I was doing a matter at Maiconi. The accused said he did not sign the statement either. And the then magistrate Meta Ozolo, she would have embarked on a voir dire to decide on the voluntariness of whether indeed he did sign the statement. And what he failed to understand is at the end of the day, the magistrate conducted the voir dire. We called all the witnesses, the persons from the prison, because the statement was taken in the prison. They witnessed to the statement, and everybody, they talk how many times he would have appeared to sign, all the signature look like one, and then the magistrate invited him to sign something, and that was the exact way that he signed. And thereafter the magistrate forms her opinion that indeed he did give the statement, and so the magistrate did rule that the statement was freely given. So even if the person challenges the signature, a voir dire is conducted to determine whether in fact the person did give the statement.
I want to be able to get the answer to two other burning questions before we run out of here, and it seems as if we'll have to have a part two of this, Court Superintendent. And don't tell me no, we definitely will. But one of those questions now, what kind of circumstance would allow for like the rearrest and like the recharge of persons whose matters have been dismissed? So you're the prosecutor, and a magistrate, I don't know if it has ever happened, but we would have heard of cases where persons might have been charged, and just as they have been dismissed, there's a police with an arrest warrant right outside the door waiting, and they rearrest that person, recharge them on the same issue. What kind of cases or matters would cause that?
You said dismiss? Well,
Or if there's another term as thrown out for a lack of evidence, you tell me.
well, the thing of it is that the police kind of rearrest, but the determination to recharge on the same matter, that sole power vested within the Director of Public Prosecutions. The thing of it is that if a matter is thrown out, let us say you said dismiss, if the matter is an indicted matter and the matter would have went its logical conclusion and the person would have been found not guilty, then the magistrate throws the matter out, then the police cannot arrest. And I stand guided here, but or I'm subject to correction, but I know for a fact is that you cannot rearrest the person after the person would have presented himself through a lengthy trial. The magistrate finds the person not guilty and dismisses the matter for insufficient evidence. And insufficient evidence may be due to many things. For example, you might have, let us say, a felonious wounding or an unlawful wounding. The prosecution failed to tend to the medical or ask the witness to exhibit his or her wounds. Then the magistrate have nothing to go on that indeed the person was indeed wounded. So the magistrate throws out the matter.
So technically, you're saying that matter can be brought back if it is that in the first instance the police feel that they have a strong case. Now that they at this point in time when it's gotten thrown out, they've got the evidence that is ready to be presented, and they get the DPP to be able to actually say, well, recharge.
DPP in a sense like that, if the matter is thrown out and the evidence is the matter can be dismissed, but nothing precludes the prosecution from submitting the report and forwarding it to the DPP, who will re-examine that case to see if the possibility existed for the matter to be appealed. But there are case laws to the fact that you cannot recharge a person on the same facts for the same circumstances. It is deemed what we call double jeopardy, and the person will come and actually for acquit and actually convict and all these manner of things which are Latin phases, but it goes mainly to show that the person would have been charged and tried and the police arrested him. But bear in mind, nothing precludes the police from rearresting the person and charging them for a similar offense arising out of the same issue. Right? So the police can very well arrest you. For example, let us say robbery and arms. You get off on the robbery, but you would have, during the robbery, you would have either lashed a person or you discharge a wrong, wounding a person. The police said, well, listen, just give you the robbery and arms. They failed on that. Nothing precludes the police from arresting you and charging for unlawful wounding. And that is one of the things that I would encourage some of our detectives. If a person use a gun or a weapon, a knife, cutlass, anything, to rob somebody, don't just go with the robbery. Once the victim sustains injury, then bring the backup charge. The robbery have its own elements that you have to prove. The wounding also have its own elements that you have to prove. So one act can give you a spin-off of multiple charges. So nothing precludes the police from rearresting you and charging you, but what the police cannot do is arrest you and charge you back with the same facts for the same offense. It is deemed in law as double jeopardy. Actually, the defense is going to raise those issues, right? Of actually for acquit and actually for convict and so on.
All right. My final question to you before we run out of here: what's the difference between dismissed and discharged? If a person has a case or a matter dismissed or it's discharged, is there a difference?
Yes, there is a great difference. A discharge, I will start with the discharge. A discharge, for example, you might have somebody who's charged, let us say, with, let us look at the capital offense murder. Now, for some reason or the other, the magistrate would have discharged the accused person because some evidence would have been lacking. Now, after the matter would have been discharged, but there's fresh evidence comes in, then the DPP can direct that the person be recharged or directs the magistrate to reopen that case and takes the evidence. And we would have had quite a few of some of those, of which I do not wish to mention here, but they were public knowledge, right? And as it relates to the dismiss, I would have went through it again.
Yeah.
Dismiss matters cannot be brought back,
Correct.
right?
Correct.
Once the prosecutor once the prosecutor would have given the matter there, or the defendant would have presented him or herself there to be tried, it is the prosecutor's duty to ensure that all the evidence are presented to the best of his or her ability to convict that person, and failing to do that in the matter dismissed the matter, but bear in mind nothing precludes from having the matter appealed.
Assistant Superintendent Shellon Daniels, Court Superintendent of Regional Division 4, you said a 60% success rate. I'm sure before the end of the year you're hoping for it to be higher.
Exactly. With the how things going right now.
How things?
Yeah, we have virtual witnesses from me. I would read my files on a daily basis. And, one of the things that once I observed something, I would call in the prosecutors. I said, listen, you said the witness is not appearing. Did you try calling the witness? One instance, there was a number, it weren't too clear. So apparently the prosecutor indicated it was a wrong number. So what I did, I tried 8-1, it did not work. I tried 5-1, and I got the person. So I said, this is ASP Daniels, I'm calling from Breakdown. Why is it that you're not attending court? So the police never called me. So I invited the person down, he came, lays him on with the prosecutor, and he went and he gave his evidence. So I'm going to encourage, in my closing word, I'm going to encourage the detectives to always take a contact number from the virtual complainants. It assists us a great lot in the presentation of our cases, because now you can not only call the persons in to give evidence, but you can have them give their evidence via Zoom or virtual settings, because with COVID, you don't want overcrowding of the courts. So that is my final thought, and thanks again for having me here.
And thank you very much for an informative hour, and certainly hope that you will be back again to share more with us on the workings of the court, particularly in the magisterial district of Regional Division 4A, ASP Daniels.
At my pleasure, anytime. Thank you.
And that has been another edition of the Police and You. Big kudos and thanks to the Corporate Communications Unit of the Ghana Police Force. We've got Raj Bali, Hussein, and Brown, as well as Team NCN with us. And very good night, and big thank you to ASP Daniels of the Court Superintendent's Office and her team for sharing with us tonight. Continue the conversation on our social media platforms. Thanks for joining us, and do enjoy the rest of your night. It's time to join Paul Moore for the news.